You may be just starting to go through divorce or separation, or you may be just about to step into the family court. And people always worry about what is going to upset the judge. What are you going to get in trouble for, and what is the right thing to do? So today we're going to be talking about 10 things that can potentially ruin your case. And if you aren't even anywhere near the family court, it's still a really good episode to listen to, because the mistakes that you make and the steps that you take in these early stages filter through into court later on.
Absolutely.
Welcome, Mum.
Hello, Laura. Hello, everyone.
So we're not doing this to scare you today, and we're not doing this to shame you, but we're opening the door and letting you peep in to see some things that later on people kick themselves and go, oh, if someone had told me that, I wouldn't have done that in the first place, and I wouldn't be in this mess now. And so anybody going through divorce or de facto separation, listen to this episode, follow these 10 principles, and you will be better off in the long run.
I agree. I mean, sometimes you don't realise you've done the wrong thing until you've done it. And then your lawyer or someone goes, you shouldn't have done that. And so this is our forewarned is fought.
Yes. But before we get started, a reminder, Mum is not your lawyer. I am not a lawyer. We're not psychologists either. We're just sharing the experience that Mum has seen throughout her 35 years of legal stuff and sharing some knowledge that we've learnt through working with members in our divorce course. So let's get to the jingle and let's get started.
Hello, I'm Laura, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
All right, Mum, we've got 10 things that we're going to touch on. And there are some things in here I wish I'd known. So we're really going to make sure everyone listens to these today.
We are.
Number 1, the most important and the whole point for family court if you've got kids. Not all of these are kid related, but this is the number one. And the biggest mistake you can make is ignoring the best interests of the children and not being focused. Everything you do and everything you say is for the children. Mum, can you explain why this is a big boo-boo if you don't follow this from the start?
There's a phrase called child-focused, right? And if you are held to be or thought to be child-focused, that's a wonderful thing. If someone says you're not child-focused, it's damning. So, and those decisions about how they label you will come through in your family report or through the judge. So the best interests of the kids are absolutely paramount. And you've got to make sure, I guess in extreme cases, I think I've seen cases where people hate their ex, it seems, more than they love their children. You know, I know that if you're listening to this, you're trying to do the right thing. You love your kids. So make sure the court can see that everything goes through the lens of the child.
Yeah.
Because a child's experience of your ex is different to your experience of your ex.
And
so
that
don't rub them together. Don't put them together. Yeah.
And that can be hard for people, especially if they've gone through trauma or abuse. And if you are triggered, please call 13 11 14 Lifeline. Or if you're going through abuse, call 1-800-RESPECT. But, you know, a lot of people, and I've seen this, and it makes sense that they would be saying, but he or she did this to me, he or she did that to me. And whilst that makes complete sense, you'd be like, warning, danger, this was going on. But the fact is you're saying he or she did this to me. And it's not, you're not even mentioning the children in that sentence. And whilst everybody else gets exactly what you mean, of course, well, if they did it to you, of course, they're probably going to do it to the kids. And that makes complete sense to say it. But Mum, how do you rephrase it? How do you make it child focus?
So you rephrase it to talk about the children in it, simply enough. So if there was a shouting match, mention where the kids were. Could they have heard it? Did they come up to you afterwards and did they say anything? You know, that sort of thing. It's the impact on the children that the court's looking at. Sometimes if you are completely quashed and distraught after a conversation, maybe you don't parent to the best of your ability afterwards. But mainly it is just take a look through the children's eyes, because that's the reason they have independent children's lawyers, you know, Laura. If they think neither parent is able to compassionately and clearly think about the children's point of view, the court may appoint an independent children's lawyer.
Have you seen judges get really mad at people who are just not focused on the kids? What kind of things do judges say?
Well, no names, no pack drill, but I absolutely remember standing in front of a female judge and she said, I'm just sad that I have to choose one of you for the children to live with.
Oh, gosh.
She
Right.
said, I haven't got a magic pop-up parent who will focus on the children's needs and not get them, it's really hard with everything else going on to think about the kids. But there's videos and things you can watch. They're very confronting. And the kids miss nothing. Even little kids know
And if
there's tension.
If a judge has got to choose between the two of you, like you said, if you're the one who's being child-focused, you're the one who's thinking about the children, how is this affecting the children? If I make this decision, how does that affect? And the other one's just completely not giving two hoots about it. I'm guessing the judge is going to be more in favour of the person who's being more child-focused, I guess.
Absolutely.
Okay.
And that's where that argument about 50-50, I want 50-50, that's an argument about fairness for the parents, isn't it, really, rather than looking at the best interests of the children.
Okay.
So that's a tricky one.
Now, I know you might be thinking, oh, well, I'm not going to be in court, this is something, but the decisions you make early on really matter. So please, and if you are in that tricky situation, go and listen to some of our parenting episodes, our co-parenting episodes, and really just double check, are you thinking about the best interests of the children in every decision you make?
Yeah, and the Central Practice Direction specifically says that these rules, these expectations of the court, these principles of good behaviour and constructive behaviour extend to way beyond you're going to court. So you might not think that it's going to come into court, but the court legitimately looks back at everything you've done since separation.
Right. So number 2, one of the other big things that really upsets family court judges, and I like to remind people, like a family court judge is sitting in a room with no windows, dealing with people going through divorce for family court day in, day out, sometimes seeing, 6 at a time, 6 fighting couples at a time?
Yes. And more sometimes than in a day.
And it kind of reminds me of when my kids were younger and they were fighting. Or I remember, Mum, fighting with my siblings and then coming up to you and going, blah, blah, blah did this to me and now blah, 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 and you would be like, oh, my goodness. And then you'd punish both of us. You'd go, both of you to your room, both of you don't get dessert. And I'd be like, but that's so unfair. You did explain that to me a little bit. And now when I look at it, I'm like, okay, that's how a judge is looking at people in a way because they're sick of it.
Yeah. And I mean, I may have been a bit unfair on you. One of you might have been right or entitled, but I didn't have time to unravel it. And nobody was paying me to unravel it. So I was sending off. But the judge is being paid to unravel that. So they're sitting there in a broom cupboard, essentially, day after day with squabbling couples going past their bench, and they have to deal with.
So you're listening today and your case is the most important thing in the world to you. You probably think about it. You probably eat thinking about it. You sleep thinking about it. You probably dream about it. You probably walk thinking about it. So number 2, one of the things that really upsets family court judges, remembering that lens, when you walk into that room or even when you're just writing letters to each other at the start, focusing on the emotion instead of the law. When you're just fully, and I don't know how you take emotion out of it, and we do talk about that in writing your affidavits, how to take the emotion out of it. But if you don't take that emotion out, if you don't take whatever you're going through out of it and just focus on the law, it really upsets judges.
Yeah, it does. Look, the way to take emotion out, the easiest way is to just state what happened. I seem to remember an old cop show that used to go, just the facts, ma'am, just the facts. So, but you put your flavour in it, like if you were talking about your work day, for instance, you wouldn't say, I dragged myself out of bed at 6 o'clock every morning and that so-and-so didn't help. That you wouldn't, but you say your truth. As I got up at 6 every morning, I was sometimes quite tired. You don't, the judge is not going to make an order based on your assessment of your ex's character or even your assessment of the behaviour of everyone. They've got to make their own mind up based on what's presented to them.
Well, and what do the judges use? What law? So they look at the law. So it's the Family Law Act. So it's basically they look at the Family Law Act. So remind yourself when you're going through this, guys, that yes, there is the emotional side that you have to deal with, but the judges don't care about that. Not really.
No, it's not going to help them make the decision in accordance with the law and efficiently. And of course, they are required to follow the law and apply the law properly because they are subject to appeal. And if you waste your very precious words and your judge's precious time on stuff that's very important to you, but not relevant to the act, then you can cheese them off quite quickly.
And if you've got 10 pages to write an affidavit and you use 5 of them to talk about things that don't even have any relevance to the Family Law Act, or if you get so hyper-focused on something, wanting justice for yourself, it may quietly ruin your case without being focused on what's really important. So let's just quickly do number 3, which is tailing into that, like you said, Mum, treating court like therapy. We've talked about the emotion thing, but one of the things, venting, blaming, storytelling, no facts, but really the big one is labeling your ex as a narcissist.
Absolutely.
That's a big no. So family court judges hate that?
They do, because we're not psychologists and you're not a psychologist. Your ex may be displaying narcissistic behaviours and you will identify them, but it might be that's just how they, maybe in the litigation, or they're just jerks or, horrible people. But that doesn't mean they're narcissists. And it doesn't mean anything to the judge either, but it does look a bit disingenuous if you leap to that conclusion. So don't do labelling. If you want to say anything, describe their behaviour and its impact on you. And if you've got a lot of incidences like that, you could put like a summary, like, during the relationship, she was financially controlling, and on a number of occasions, I wasn't able to access money, however, but for example, and just put 1 or 2 or 3 examples, and then the judge can join the dots, okay? Could seem to be controlling you financially, you couldn't access money, you could even leave out financially controlling and just say, I was always broke, they had all the money. That sort of thing. And then the judge can join the dots.
Remind yourself, you're not a psychologist. We aren't either. So you're just giving facts and let the judge, you call it a little breadcrumb trail to get them to the conclusion.
I was told that as a young lawyer, you need to lead the judge to the conclusion that you want them to have by putting the breadcrumbs down and letting the judge reach the right pathway.
And when you really think about it, if you say, my ex is a narcissist, do something about it, the judge is going to go, what do you want me to do? There's nothing in the Family Law Act that says you can't be, that if you're a narcissist, this happens. It's all about their actions. It's all about what they've done and what they're doing.
Yeah, and if the judge gave you an order that says that your ex is a narcissist, what's that going to do? It doesn't impact on your lives. There's nothing you can use it for. So a lot of people go to court looking to be exonerated, to finally tell someone what they've been enduring in silence for all of the years. But you've got to remember, the court's coming in halfway through the story, maybe even only at the end of the story. So it's very easy for them to misidentify who's the problem. So just be very regular and steady in how you report what happened to you, and mainly focus on the things you can talk about from your own experience.
I think something that we've all learnt, talking to lots of members and myself, pain of going through divorce is real. Okay, but court and the legal process is not where you process it. It's not the place to process it.
They don't offer processing. They just offer a way out of it without each of you ending up in fisticuffs,
Okay, number 4, a really practical one. Really upsets family court judges if you don't understand how evidence works.
It's a bit unfair, isn't it?
Well, it is. But if you're self-repped and you're trying to go, oh, no, don't worry, I've got proof, I've got evidence. How do you not upset a judge by not having any proof or done it properly? How do you do proof properly?
Oh, wow, that's a big one. So the Evidence Act in federal courts is this thick, and it's massive, right? But the court can only make decisions mostly based on evidence that's put before them. So it's got to be relevant to what they've got to decide. So relevant to one of the sections of the Family Law Act they have to apply. And it has to be admissible. Like it has to not have been something said in negotiations. And then those sorts of evidence that you put before the court, you shouldn't draw your own conclusions from them. You attach a document and let the court use it, let the judge use it. So it's unfair to expect litigants in person to know the rules of evidence when a lot of lawyers don't. And the court has a power to, in the Family Law Act, they don't have to strictly follow the rules of evidence. So if it's really beneficial to the children, you can get that information before them. That might help for the kids. But so there's ways like subpoenas is one way, affidavits is another way, but they all really happen usually deep into the court process. And you've got to make sure that it's not something that you've got that you can produce, but it hasn't been properly, I guess, obtained, or it hasn't been shown to the other side or something like that.
So there's a lot of
tricky.
rules when it comes to evidence.
So many rules.
Do people make mistakes and just go, well, it's an assumption, or it was here, like the hearsay, or my friend down the road said he said this to me? Like, does that count?
No.
So it's really got to be proper.
So you need like first-hand evidence from a person who's seen it or done something. And examples are, you would never say he was drunk when he drove off. How do you know that? So in the old, like the magistrate's court for drunk driving, you'd have to say he smelled of alcohol, or she had trouble getting the key in the ignition. I'd seen her drink 3 wines, that sort of thing. But you don't draw the conclusion.
So that's that breadcrumb thing again. It is. It's not saying they were drunk when they drove off. You've got to kind of go, well, they'd had 3 drinks, they were struggling and slurring words. So it's really describing. And you have said to me before, and we've done we've done an episode on subpoenas and evidence, so go and listen to those episodes. But you have said before that the family court standard of evidence is a lot lower than the criminal court.
It is. So in the criminal court, it's beyond reasonable doubt, right? So it's a very high standard of proof, and a lot of people get away with things that you would think they should have been, sentenced for. But in the family court, their standard of proof is a different standard of proof. It's a civil one, and it's on the balance of probabilities.
Right.
So, and when you give this sort of evidence of what happened and who said what and how, what you observed, you are the expert on that. So you could be cross-examined on that. Oh, well, when you say that you saw them have 3 glasses of wine, where were you standing when you saw that happen? Did you really? And so everything you put before the court has to be something you have such a good knowledge about. It's from your own experience that you can be cross-examined on it.
And that takes us to number 5. One of the things that really, I think this probably makes judges like eyes pop out of their head and their brains explode. You know that emoji where they've got like fire, brain exploding? Lying. So,
oh my gosh.
So even inconsistencies can unravel a case. What happens once a judge picks up this person's inconsistent or is full lying? What does a judge do?
Well, what the judge then, if they've got to choose between 2 versions of an event, they're going to choose the version of the person who hasn't been shown to be lying. So you lose your credibility if you've caught lying. I mean, when you have a court case or even the separation, right, you can forget what happened. You could swear blind something happened on a Wednesday, and then someone produces the evidence, shows you, no, look, it was a Thursday. I could have sworn it was Wednesday. Well, you probably did swear it was a Wednesday. But you should then change and go, I've since learned that I was mistaken and it was Thursday. But so you expect a little bit of a argy-bargy and different versions of events, because sometimes you're looking back over 20, 30 years of history. And that's legitimate. As the case becomes clearer and evidence gets found, most of you will be in alignment on most of the facts. But if you, in the face of all of that, still maintain it was Wednesday, and then even when they show you're wrong, you still maintain it, well, then the court's not going to have a lot of confidence in your evidence.
Have you seen big liar, pants on fires get their comeuppance in court?
Yes, it's very disconcerting, especially if you're their lawyer.
What do judges say?
You.
Have you seen a judge say something to a liar? Or?
Lots of times.
What kind of thing do they say?
Well, the worst thing they could say is to the lawyers I suggest you take your client out and have a discussion, or I suggest you go and settle this. And I've seen a couple of cases where the other person's lawyers, other person's in the witness box and sitting thinking, how am I going to get this evidence in? How am I going to do it? And then they just tell this biggest porky pie lie, which means that you get a chance to correct them and show them the evidence. If you lie in your early material, it's like garbage in, garbage out, right? If you're telling your solicitor lies, if you go to mediation with lies, or even to a barrister for an opinion on lies, well, then you'll just get outcome based on that lie. That's what they project your outcome will be. But if you go to court and you get caught in the lie in the witness box, that wasn't taken into account when you got all your earlier advice. And you may find that you have to settle or that you should have settled yonks ago if only they'd known. And in a very bad situation, sometimes a lawyer will reconsider whether they will continue to act for someone who's not telling the truth.
Do barristers try and get you to be caught out in a lie?
Oh, yes. That's the whole aim.
Right.
That's it's not it sounds nasty the way you say it, but what they're doing is testing your evidence, because in the family court, nearly all evidence goes in by affidavit. And that includes your own evidence, any of your witnesses' evidence. And remember when I said you've got to know what you're talking about, you've got to talk about it so you can be cross-examined. So the barrister's job is to, not your barrister, the other person's barrister, their job is to shake your confidence on that, to dig down and try to get you to go, no, I was wrong. Try to do that. Or you say something and they go, well, in such and such, you said this, and they can give you a document and, just catches you off.
So
being,
really just got to be honest. And if you've got to face a bit of consequences, it's better than that than ruining your case. We've done an episode called When Your Ex is Lying in Court, He Says, She Says Saga. And a judge can choose, can't they? Well, this person's been caught out lying, so I'm going to believe this person for everything, the other person for everything they've said.
Yeah, but also too, especially in property settlement, there's a range of outcomes, probably ranges over 10 or 15% between the lowest you might expect to get and the highest you might expect to get. And if they're really upset with one of you, if it's you they're upset with, they may give you the lower percentage that they legally can give you rather than giving you the higher percentage.
Okay.
So it does really impact. Yeah,
all right. And speaking of property settlement, this gets us to number 6, failing to do proper disclosure. Now, this really is upsetting some judges recently. Aren't there cases recently, Mum, where the judges have done some things?
You're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum, and family law accredited specialist to answer your questions. All you have to do is go to www.thedivorcecourse.com.au and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today.
There have been recent cases, but always the courts have been angry about this. So the Family Law Act has just been amended so that now under Section 71B of the Family Law Act, instead of just being in the rules, it's now a section in the Act that says that you have an ongoing obligation to make disclosure before you go to court and even after court started, and you've got to keep giving your documents over all of the time. And I think, Laura, sometimes we could have a podcast just based on disclosure because it really worries people.
And we do have delays in disclosure.
Not making a disclosure, not showing the court all of the documents or not showing your ex all of the documents is a very grave sin in the eyes of the court, because how can someone assess whether they can make an offer that's reasonable? How can the other person assess whether they could accept an offer? Is that reasonable? But more importantly, how can the court make an order that is just and equitable between the parties? And they must not make an order unless it's fair. So disclosure is like the linchpin of the whole Family Law Act in property and children.
So how can it ruin your case?
Well, the court can just, if you haven't made proper disclosure, one of the rules is that if you haven't shown a document to your ex, you can't raise it at the trial, even if it's something that's really important to your case. No, you should have shown that before. So that's one way they do it. If it's not in the appropriate line of the preparation for court, don't try and mention it at the hearing. If you don't make any disclosure, the court has the right to perhaps send your case to an undefended hearing. So the other person doesn't get a say, really. It's just whatever the offending person, the non-naughty person, says.
Pulling their hair out.
Yeah. So I think all of our listeners should look at the Central Practice Direction. WA has one similar, and that practice direction extends from way before court and leading through, and it talks about the consequences.
Well, let's get to that in a minute. Just a reminder, though, and Mum, you wanted to point this out, failing to do proper disclosure, even if your ex is refusing to do it, why is it important that you should still do it?
I'll tell you why it's important, because the court, these two kids fighting, and the parent says, why didn't you do this? Oh, because he didn't do it. Get your material in, right?
Yeah.
It's no excuse if your ex is being lazy. Even if your ex, if she hasn't given a single document, you've got to be as pure as you can be and be absolutely up to date so that you can stand before your mum or dad or the judge like sort of the goody two-shoes who's done everything right. Because when the judge wants to rant or identify the reason the case is being delayed or held up or whatever, they will swivel their eyes away from you and focus on the other person. But they have no time for, I didn't do it because they're not doing it. How childish does that sound?
Yeah.
And it doesn't help the court.
Yeah.
So if you've got court orders for the timing to do stuff, do it. Keep yourself dead on time for everything, even if the other side isn't cooperating, so that you can stand up and say, well, I'm ready. And you may find yourself going to your conclusion. What never happens is non-disclosure cannot and will not end, won't stop a case happening. So without the disclosure, the court can draw their own conclusions. The other person can put best evidence forward. And so,
yeah. Okay.
It's important.
Number 7.
Okay.
And we touched on it already. You've just mentioned not following the practice directions.
Yes.
So can you explain what they are and why they're important for everyone listening, whether you're at this, before you've even seen a lawyer or before you've gone to court, all of that, you need to kind of get yourself around it. Can you explain what central practice directions are?
Okay. So the law for family law in Australia is from the Family Law Act or its equivalent. That's your legislation, right? Then the cases that have been decided, they're the judge-made laws. So your legislation's the government-made laws. The judges interpret it, and that's why we quote cases and things. But it's hard to find the law, the cases, and the rules. The rules are also put out by the judges, and they've got different things to do. And you can easily get bamboozled. And the aim of the court really was that people could self-represent if they wanted to. And so in the interest, I think, of clarity, the court has issued practice directions. There are practice directions for financial matters and practice directions for children's matters, and they're just much easier to digest. And if you've got them in front of you, you're not going to go too far wrong. But in 2021, they put out the central practice direction, and this is like core principles of the court. It's multiple pages, I think 30 pages. It tells you what's expected at each step of the way, and you can quote them at the sections and write to the other side and say, you're in breach of practice direction 1.3 or whatever. And the court has done that as a kind of interpretation of what they expect and how things will be done in the court. This doesn't really have the highest, it's not like rules that have to be sort of very clear, and it's not like the government's legislation because they do that. It's just, this is how the registry is going to operate. This is how we're going to manage our caseload. And I think if you don't have that, I have a hard copy printed out, and I know most lawyers do have a copy on their screen most of the time, because if you follow that, you can't go far wrong.
And it's kind of like a little handy guidebook. You just look at what are you up to, go and read and go, oh, okay. And if you are self-repped, you can be like, well, I read the central practice directions and it says for mediation, we're supposed to do X, Y, Z. So, there are things in there. So it's got format, court rules. It kind of showing the judge or showing your case that you're organised, you're trying to follow the rules, and you're not disrespecting the process, I think is really important and a good way not to upset a judge.
It's very comforting for you.
Yeah.
And no one can criticise you if you've followed those practice directions from the court.
That's right. Number 8, and this you'll have to kind of explain this a little bit for us, Mum, but I had it as not narrowing the issues and just going in front of a judge and being like, sort it all out for us.
Yeah.
And you're saying, what really upsets a judge is when people go in there and fail not to agree on anything that's obvious that you already agreed on. Is that what you're saying?
Yeah, I think so. I think there's people who think that you can drop your whole mess in front of the judge and go, can you sort that out? The court wants you to try and work out what you can by mediation or between yourselves. And then if you think of it as a great big knot, and as you gradually sort of unpick bits of it, you can solve a lot of the trouble, a lot of it yourself. And what you should go to court with is just that nutty bit, that hard bit in the middle that you can't quite work out yourself. And so they call it narrowing the issues. It's the point of mediation and other communication. And most people say, oh, well, we'll agree to that, but we still don't agree to this. Okay, well, what about if we tell the court we agree on all these things and ask the judge to talk about this one thing? So what you're doing is that's a much more efficient use of the court's resources. However, there's one bad thing that I want to say, Laura.
Yeah.
Some people will say, I'm not sorting out children until I sort out property, or I don't want to sign a parenting plan until I've got property settlement. I don't want to do, or I'm not agreeing on anything. You can't sell the house or anything unless I get my car back. Like just holding people to ransom for silly little things. And the court's not interested in that.
Right.
Absolutely. But evidence might not get before the judge about you saying those things until they go to work out costs.
So what's going to upset a judge really is what you're saying is if you just walk in there and drop your entire, every argument, every decision, everything on their desk and go, sort this out for us, please. Because the judge is going to go, seriously, you can't even sort out who takes the kids to the soccer game next weekend? Like, surely you could
sound like a judge.
Surely you could sort that out. And so I've actually seen, I've sit in the back of court of some things. I've seen where the judges read out all the issues and go, surely you agree to that, don't you? And then they freak out. They go, yes, I do agree to that. And so, you don't want the judge to be thinking you are that incompetent and that argumentative and that horrible to each other that you can't figure it out. And don't get me wrong, though. There are going to be people listening to this undoubtedly who have exes who are that horrible, who don't want to agree to anything. And you are going to go in front of a judge. And like you said, Mum, they're not going to know who's the pain and who's not at the start.
Yeah,
so it really is going to upset the judge. But if you can continue to show that, and like you said, you've tried to make this agreement, here's examples of you trying to agree, here's you being reasonable and them being unreasonable. Is that kind of how you get around it if you've got one of those kind of exes?
No, you can't use that in evidence.
Really?
Because, yes, you can't use evidence of negotiations before the court.
So what do you do?
You use it after the court's made a judgment.
Right.
Then in submissions about costs, you can say to the court, Your Honour, we are only here today or these last few days because that person wasn't reasonable and here's my letter and here's their response and here's my other letter and here's their response. And so I want him to pay or her to pay my legal fees from the day that I sent that offer over. So that kind of, it comes to play in costs.
Okay.
But when people are being cross-examined, the barristers will generally be able to provoke a person who hasn't got a genuine reason to object to something. They can generally nail them down and they go, no, well, why not? Can you explain to the court why not? No, I just don't think so. And that court calls that not making appropriate concessions. So
there you go.
Yes.
Okay.
It does seem, Laura, sometimes that they ask a lot of us. The court expects litigants out of a marriage, fresh out of a relationship,
fighting,
to be as placid. And yet they're to operate almost like automatons, like robots, in terms of just getting through the facts. But I guess we have to all try.
I know, but it's a big ask. All right, number 9.
Okay.
And we put this one in here as a warning to everyone. I don't think anybody is deliberately doing this. And if they are, I don't want them listening to our podcast. But undermining the kid's relationship with the other parent, that doesn't, I'm hoping all our listeners don't do that. But sometimes it would really upset a judge. And sometimes people are just genuinely like, no, I think it's a bad idea. My kid's around this person. Like it's a bad idea. But if parents say things like, little Johnny hates dad, or the kids don't want to go, but there's no evidence, there's no backstory, there's no abuse, there's no anything, do judges instantly start thinking of that alienation word? And does that get people in a lot of trouble?
It can. When you say there's no abuse or none of the other things, there's no evidence before the court of those things. Yeah. And you don't want to be the only evidence that you draw that conclusion and feed the court your conclusion. It may be entirely valid, but in days now where the court is looking at the best interests of the children, they're looking at who has been the primary carer and who should care for the children going forward. But there's property settlement consequences and child support things, all that hang off there. And sometimes if there's been family violence and for that reason you're not wanting the children to go, I'm afraid a very common, tacky response is an automatic, you're alienating the children. They're suggesting that the children feel that way, not because of their lived experience with your ex, but because you're making them feel that way. So to avoid the court looking at you and maybe swallowing that narrative, you need to, again, don't draw the conclusions, right? Your evidence is sus as far as the court's concerned. when it comes to that, right? Because how can they tell which one of you is lying when you're each saying different stories? So it's going to be family reports or another way that the evidence gets in before the judge of who's doing what. What you can do, though, because you're there with the kids, is you might be able to say, when their mother comes to pick them up, little Johnny runs and hides under the table in the family room. I've tried doing this for him or that for him, and he has a tantrum, he screams, won't go. You can say that's what you've seen. You can be cross-examined on that. But you shouldn't draw the conclusion from that your child hates their ex. Your experience with your ex is different to the child's relationship with your ex. And actually, several children in a marriage they all experience their parents differently. And so it's not for you to say that they hate going or anything. So you can put your concerns and what you've observed.
And I think it's a really important point. And look, I know there's heaps of people out there who are trying really hard to protect their children from abusers. And we have done a whole episode on when abusers use parental alienation as a weapon and to say that it's, the kids don't want to come to me because of what I put them through. They don't want to come to me because that parent is making them hate me or whatever it is. So that is a really common tactic in court. And
Very
again,
common.
Not everyone gets to court, but like you said, Mum, it's the ones that get to court are the ones that are usually, it's like 80% family violence cases I was reading the other day. So of course, there's a lot of that going on. And so there's a lot of tactics where they say, oh, they're accusing me of abuse. So I will say it's parental alienation. That's their go-to playbook. And so
it is.
You've got to be really careful about how you go about it and make sure that, like Mum said, you're stating the facts, you're stating what you're observing and getting outside special people to give it more gravitas so that you're not labelled an alienator. Even though that there's a lot of research that says that parental alienation is not a psychological thing.
Yeah. Do you know, one of the most powerful things a client ever said to me was when we were sitting with the barrister and the barrister was saying, why do you say this shouldn't happen? Or why do you say this? And she said, it's not me. It's not for me. I am my child's spokesperson. I'm presenting what happens with them, and hers involved the child vomiting and holding on to rails and things. And she went in she had no way of knowing if anything was wrong in the other household, but she said, I've got the obligation to put all the evidence forward and let the court make of that what they will. And I think that's the powerful thing. You don't want to go in looking like you're advocating for yourself to have your child. Yeah. You go in and say the things that you think the court should know about what's happening with your child, and then that evidence then becomes part of usually what a family report writer can look at. And they're quite skilled at working out if a little kid says, I hate mummy or I hate daddy. They're quite skilled at identifying if it's like a parroted response. The one that happens most often is they're talking about things that they can't possibly remember. In one case, the little girl wasn't even born. So they've obviously been told something by a parent. Yeah. So
there's a lot of unpacking in that, but just be mindful. If you go in and say little Johnny doesn't want to see their parent, it can ruin your case just because you've got to show and give the evidence to the court. Otherwise, sometimes judges jump on that alienation train. We've got an episode called Hand Over Hell. So if you are having trouble with getting them to the other parent, what you can do about it. We've got that parental alienation being used as a weapon by abusers episode you can go listen to. And hopefully some of those can help you. And if you are going to do a family report, which is one of the ways that they can find out that information, go and listen to that episode as well.
Yes.
All right. And big hugs to anyone going through that. I know there are people that kids are rejecting them because they're just not coping with the divorce process, or they've got teenagers who just want to stay in one house and not the other. We know there's a lot of hurt and pain going on there, but sadly, we're seeing so much false alienation accusations. Yeah. It's really quite horrible, and we wanted to warn you all about it. Now, lastly, number 10, and this covers everybody right from the get-go, just before you've even left. Failing to act reasonably when given a chance really upsets judges. So, Mum, give me some examples. Why do people really need to make sure they're always acting reasonable?
Yeah. I think those tips, like when you said that when the judge says, surely you can reach an agreement on that, Most people take the hint and go outside and sort it out. If you don't, then the courts, that they can look at you and think this person is not wanting to resolve the case. They may get the idea that you're having fun doing the case and wanting to drag it out to talk to the other person or whatever. You need to be able to have a good look at yourself. You need to be flexible and, as you say, make appropriate concessions to things when it becomes obvious. A lot of people with lawyers say they get really pressured in court to reach agreements, and I can see why sometimes their lawyers do that.
And mediation.
And mediation. But you know if it's not good, if it's not reasonable for the child, you can resist those things. But when the judge does it, it's tricky.
But if it's
they haven't heard all the evidence.
If it's basic stuff that gets put in front of the judge and says, oh, we had to do this and we needed to change this date, and they flatly refused, or you know, they were supposed to return the car on this date, but there was a cyclone, so they just said I didn't need to return it because the date went past. Or that example you gave where they said handover was at McDonald's at this specific suburb, and the McDonald's shut down, so they just then assumed they didn't do handover anymore.
They didn't. I don't think they assumed they didn't. They just stopped and thought they were playing hardball by the orders, thereby that they were not child-focused.
Yeah, and that kind of behaviour really is a red rag to a bull for judges. And
they don't come home with you guys. They haven't been in the relationship.
Imagine the judge following you home just to see how it's all going in your house. Gosh.
But in these things, this is where that person's true nature came to the fore. They might have been able to walk the walk and talk the talk, and the lawyer might have tidied up their affidavit so it didn't sound so aggressive. But then first opportunity, they thought they were just very clever, and it really went badly for them. Laura, we forgot to mention dressing appropriately.
Oh, well, of course. Yes. I mean...
But I mean it, and acting appropriately. Because there is a lowering of standards in clothes. I mean, depends who you are, but don't turn up at the court in your leisure wear, your exercise clothes. I do remember someone in a divorce about 30 years ago turned up in her tennis outfit, and the whole court everyone in the courtroom got a lecture about appropriate attire.
The best thing to remember is the family court, from what I've seen, is maybe 40 years behind in fashion and in understanding of, I don't know. It just gives
the
way that the people behave, the way you have to bow the judge, all that stuff. It's kind of like 1940s, 1950s behaviour. So just imagine you're going to back in the past. You're not going to turn, even just not wearing stockings was a bit of a scandal 10 years ago, wasn't it?
It took a while. Yep, I've always worn stockings to court until I noticed the Chief Justice in one of the state Supreme Courts was, and I thought, right, I'm out of here for that.
Yes.
But it was probably, let me see, about 20 years ago, a certain judge refused to listen to a lawyer who had trousers on. And so when you think about it, this is a very old system. And the gowns that the barristers wear and the wigs that they sometimes wear, they're from the 1700s, right? And so this is built on tradition. And it's an easy thing to do. Just put something nice on, wear a jacket if you've got one. Don't wear anything skimpy. Just take it seriously.
And I think, like we said, think of the judge as like a parent who's been dealing with naughty kids all day, or a school principal. And they're human. They're all different. They all have their own personalities, whether they like it or not. It does influence, and just the image you project, the language you speak, the words you write, it all builds a story, non-verbal story. The way you sit in the witness box, the way you sit in the peanut gallery, the eye rolling you do.
Oh, my goodness, yes.
So all of that affects your case. Oh. And Mum, you've talked about one where someone was eye rolling and that lost the case for them.
For me, I was the lawyer.
Yeah.
And my client was wonderful, and I was cross-examining the other person. What I didn't see was my client's husband, because it was the child wasn't their child they were asking for custody of. And when I sat down, the judge said, well, Mrs. Galvin, you wouldn't have seen it, but the whole time that Miss Such and Such was giving her evidence, so I don't think that your client's husband could be supportive of a relationship. And they lost the case.
Yikes.
So, the judges don't know you. They've read your material. They know that's usually been filtered through lawyers. And then when you walk into the room, that's the first time they get to look at, this is them. And so how you sit. Do you rustle papers? Don't talk while the judge is talking. Stand up when the judge comes into the room.
And I guess
all those things.
And just to add all to that, everything you've done from the start, and it's kind of, I did talk about this recently, like in the old days. Imagine you're Taylor Swift when you're going through divorce. Imagine everything you do, every cafe you go to, every tweet you tweet, every text message, every passive-aggressive, every meme is going to be looked at and scrutinized and written in the media. But it's not the media that's going to be looking at it, and it's not the public that's looking at it. It's a judge and it's their lawyers. And so think about it really hard and remind yourself that all the steps you take from the start to the end, hopefully you never go to court, but from the start to the end, you are following these principles. You're doing what's best interest of the kids. You're doing the right things. You're following the central practice directions, and you'll get out okay. You'll get what's fair, and things will be good for you. And I think don't be hard on yourself, because, look, Mum and I know exactly what it's like going through divorce. You do not have your S together. You do not. You struggle to get the same pair of shoes on. You're not doing your hair properly. That's just the basics. But then when you add on to that, you're trying to also go to work. You're trying to look after the kids. You're trying to take care of your mental health. And so you're all over the place. And then you're also meant to be following all of these rules. But I guess if you're a good-hearted person and you know what the judge and the family court cares about as well, you'll be okay.
Yes, absolutely. Keep your dignity.
Yes.
And be dignified. And it seems like sometimes, like you're saying, it's an impossibly high standard sometimes. But, we can do hard things.
We can. And hopefully you only ever have to do it once. Now, is there anything you would embroider on a question before we go?
I think, yes, Your Honour.
Okay. Not Your Majesty. Don't say Your Majesty, but yes, Your Honour.
If it's a registrar, you could say, yes, registrar, but they don't mind if you elevate their standing and call them Your Honour.
Yes. That reminds me, if you are going through court, you want to know about court etiquette, we've got an episode. I'll put the link to that. And we have webinar coming up. We have a webinar coming up in a couple of weeks, in the second week of Feb, I believe. So if you're listening to this and you'd love to come along and chat with us, because Mum does a little presentation and then we do some chatting after the show's over in the chat. If you'd love to come along and have a chat with us, if you're interested in just getting some more information to help you on your journey, if you want to go on your journey with us, you can listen to the podcast and you can come along to the webinar. Go to the website, thedivorcecourse.com.au, and just click register your webinar. There are only limited seats. They're 100% going to run out this time around because we have already been bombarded and we haven't started advertising yet. So if you want to come along to the webinar, grab your seat now. And Mum, you always want to say something about YouTube, so I'll pass it on over to you.
Yes, because I'm a YouTube fan.
Yes.
But if you think this has been helpful to you in any way, or if you think it might help someone else, please take a moment to like and subscribe, and that way you can get us higher up in the search results. And there may be someone who needs to hear the podcasts and needs to hear our talk.
Because we're reading your beautiful reviews. I read one the other day to you, Mum, from a lady in Switzerland, and she just said, even though the law's different, you're keeping me on an even keel and keeping me going. And I was like, oh, wow, someone in Switzerland's listening. So I'm so glad that we're helping people out there. I'm glad we're helping you keeping a level head. I hope this episode didn't scare you. I just think sometimes it's good for someone to just sit down and go, right, here's what we've got to talk about. And here's what I wish I knew. And so, we're big.
So, if you can pay it forward, that would be really nice.
Yes, just give us 5 stars. Don't even have to write a review. Just give us 5 stars. That'll get us up there. All right. Thank you, Mum, for your time. We'll see you next week. Remember, guys, we're here every week and we'll see you again. Thank you, Mum.
See you next week. Bye, Laura. Bye, everyone. Have a good week.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.